He is an associate professor from South Texas College of Law in Houston. If you are interested, if you don't know, he is the founder of Fantasy SCOTUS, which is the internet's premier Supreme Court fantasy league. I can tell you something about my friends from high school. They play that more than they can play fantasy football. But he does that through his work as a founder and president of the Harlan Institute, which does great things in terms of, it has a mission to develop condensed law school courses that can be taught at no cost in high schools across the country, and using different engaging online programs. So he is doing something to use the online systems to reach out to the greater community. He's an avid blogger, and he's been actively talking about the issues of big data. He did clerk in the 6th Circuit for Honorable Danny Boggs. He also clerked in the Western District of Pennsylvania for the Honorable Kim Gibson. The next speaker we have is Carol Roan Griesens, and she is the Jacobs Professor in the Georgetown Department of Health Systems Administration in the Georgetown University School of Nursing and Health. She has a PhD in economics from Brown, as well as a PA in economics from Loyola, Maryland. Before joining Georgetown, she spent 20 years in the RAND Corporation, working as a senior economist. Most recently, she has also served on the editorial board of RAND's Health Services Research and Medical Care Research and Review. So she is going to be talking to us about data and the use of data to evaluate healthcare services and some of the concerns about privacy that may have stopped some of the actual good research that could be done. Kathy Zeiler is our own law professor here at Georgetown Law. She also co-directs the Georgetown Law and Economics Workshop. Before joining the faculty, she received a PhD in economics from California Institute of Technology and a JD from USC. She is a member of the board of directors of the American Law and Economics Association. She is also has been a senior academic fellow at the Harvard Law School's Petrie Flom Center, and a member of the board of directors of the American Law and Economics Association. And I should point out that she is actively working with the library on many projects, and the most interesting is the one that the dean mentioned this morning. Dataverse is a unique collection of data sets, and I believe we are the only law library who's been working with academic empirical legal study faculty to preserve the data sets that they're using. So if you do have a moment to take a look at our website, please do look at Dataverse, who was instrumental in bringing the idea to us and really leading that effort. We have, last but not least, Bill Leffergy, who is the Digital Initiatives Manager for the National Digital Information Infrastructure and Preservation Program at the Library of Congress. He's been there since at least 2002, and he leads their communications team, which interacts with a broad range of people that are interested in preserving access to digital information. Before that, he worked with electronic records at the National Archives, and he served as the Baltimore City Archivist and Records Management Officer. He also holds a BA in history as well as a master's in history, the BA from McGill and the master's from Maryland. The best part of his bio is that he has memories of punch cards, microphone monitors, and 30-pound portable computers. But he's also an enthusiastic and creator and consumer of social media. And I would suggest that you take a look at his postings on Twitter, as well as his work on the Library of Congress blog, The Signal. With that, let me turn it over to the panel.
Good morning, everyone. My name is Josh Black. I'm a professor at the South Texas College of Law in Houston, Texas. Thank you to Kumar and Morgan for putting together this great conference at Georgetown. I'm going to give you a little insight into how big data can be used. And my focus is on how it can be used for the practice of law, what I call assisted decision making. If you think about it, everything that lawyers do is premised on one simple question. What is going to happen with this case? Will I win or will I lose? How do I litigate it? What is the best way to do this? And lawyers are trained for centuries. The way to do this is to look at precedents in the past and say, okay, a court did this in the past, we have similar facts, here's what will happen in the future. It's a very effective process, but it's very limited by the inherent fact that it only knows so much. Any one lawyer can only know so many cases. And it's impossible for someone to know everything. From Holmes forward, the job of lawyers predict what will happen. I offer that the way of the future is to use data to try to understand what it is that courts will do. This image we have of this lawyer is hunching over books is really something that's very antiquated, this great Norman Rockwell poster. We have to look to people like Richard Susskind and others who are using data to push forward and try to develop who the lawyer of tomorrow is. Professor Larry Ripstein, who passed away last year, called it Law's Information Revolution, that we will use data to transform the way lawyers function. And we'll do this through certain disruptive technologies, one of which Kumar mentioned. I developed a Supreme Court fantasy league called Fantasy SCOTUS. This is now in its 4th season. My friend Corey Carpenter helped me launch it years ago. This is the 4th season of the league. We have over 17,000 people making predictions on every single case before the Supreme Court about 4 blocks that way. We use the wisdom of the crowds. By looking at how all these people are able to vote, we can make very accurate predictions. This is based on the work of James Stewart and others. We can say, okay, if we have 1,000 people predicting a case we decided one way, that's probably a good indication of what will happen. No longer do we need to rely on singular experts who are usually wrong. We can look at a broad set of people who are lawyers, non-lawyers, law students, political scientists, a wide range of people. And the way this works is by just voting. It's a very simple interface. You say, who's going to vote to affirm, who will reverse? It's a very smart way of predicting cases. Okay? And as we said, we have over 17,000 players. Fantasy SCOTUS has been featured in the Times, Wall Street Journal, CNN, ABA Journal. It's been all over the place. It's a very powerful thing, building on the wisdom of the crowd. We have a tracker that lists every case for the court, what's going to happen, and we keep very detailed records of how good we are. Are predictions right? Are they wrong? Last year we had a tracker for the healthcare cases, and we actually had a day-by-day tracker. No one else can do this except for us. We can actually how the arguments and how the predictions change along the way. Interestingly enough, and Corey will affirm this, at the end our results were not statistically significant. We had no significant prediction for the case, which was pretty darn accurate because no one knew what was going to happen, not even the justices. But we had no statistically significant prediction, which is actually quite telling. What is interesting is this is a day-by-day tracker. You see that red line, that's the arguments happen, how people react to what happened in arguments. You can actually see how people react to what's happening inside the court and outside the court. This is a very good way of encapsulating a lot of data. But really this is limited. The reason why it's limited is it's based on something that's popular, the Supreme Court. Everyone knows about the Supreme Court. People don't know about the lower courts. People don't care about the district courts. We need something that's a little bit stronger, that does not rely on crowdsourcing. We need to turn from crowdsourcing to what we call super crunching. Super crunching is a way of using lots of big data, putting through sophisticated algorithms and determining how courts are deciding cases. And the avenue to do this is there's something called PACER. Anyone in this room knows what PACER is, you probably hate it. I don't blame you. It's a horrible, horrible thing. Actually, the FJC is like 3 blocks that way, if they don't hear me. Maybe I do know. But the PACER is a very bad thing. It's very closed off. But there is information in PACER that can be gleaned, and I'm working on both in the academic and the private sector approach to kind of to build a tool to get this. This is what PACER looks like, roughly. It's a simple docket sheet that lists things chronologically by date. There's a date, there's a document number, and there's a brief description. The way PACER works now is everything goes down this data drain. It's pure HTML. There is no API. There is no gateway. There is no cloud. There's nothing. There's a series of 90-something balkanized websites that have this information available to no one except people want to pay now 10 cents a page. But bear with me if you will, and assume that we can get access to this data, and it's something I'm working on in several capacities. Just assume we can get that data for now. What we have to actually do is Clemmer Neo. We have to view the law as data. We are in the matrix. We have to see, we're not looking at, documents, we're looking at relationships. We're not just looking at cases, we're looking at links. Viewing the law as a data helps do this. So I will walk you through very briefly how this works from an algorithmic perspective. So we have the top of the docket sheet. It's a little small, but we can see it. There's a lot of information. We know who the judge is, who the parties are, when was the case filed, what's the nature of the suit, This is all information that can be coded with not too much difficulty. Then we know what's the first thing that happens. We know there's a complaint filed on a certain date. Who files a complaint? We know there's a complaint filed. For those of you who like civil procedure, we know when a complaint's filed, at a certain time thereafter, there has to be a response to it. Okay? So what's the next thing? A motion to dismiss. This is actually from the Oracle versus Google case that was really big last summer. Some of you are no doubt familiar with it. So we know that, okay, a complaint was filed on this day, and then 2 months later, a motion to dismiss was filed. We can then build a relationship for your database wonks. This is how we build relational databases. And we can have all this stuff together. Then we see the judge about 3 weeks later deny the motion to dismiss. I'm sorry, there was an opposition to it. And then the judge denied it. So right here, these 4 segments are 4 briefs that are filed. But just by looking at the docket text with relationship, figure out how the litigation proceeds. From this, we can develop heuristics and predictions of how this judge will handle similar cases in the future. We can then crunch data about the cases, the motions, the opinions, dates, judges, firms, lawyers. These are all things that are available from the docket sheet, which give insight into how lawyers should litigate and make them smarter for it. And this diagram kind of represents relationship, because all this stuff is interwoven. Every single case has to do with the court, with the judge, with the person, with the law firm. This is all the big data that involves litigation. And this is data that we are harnessing. And we will give to lawyers to help them make better decisions about litigating. And I'm going to give you a brief introduction of a website I'm developing called harlan.co. Which is where, as I say, big data meets the big law. I'll show it to you right here. Okay, so can everyone see this? This is the basic website that I'm working on. It's a side project, but it might be, at some point, useful for lawyers. So instead of having this ghastly pacer which lists everything in a scroll-down sheet, looks like Yahoo from 1997, I have a very nice GUI which lists everything chronologically. And you can see, everything's on a timeline. So we see, okay, on August 12th, the complaint was filed. Then we scroll, we see October 4th, the motion to dismiss was filed. And then, on October 28th, the opposition's filed. And here we have a little preview of the PDF, the actual document itself. You have the docket text. And this allows you to scroll through the entirety of the entire civil docket sheet in one very easy-to-function way. You can jump forward, jump back, see when the trial starts, how long the trial lasts, jury deliberations. The entirety of the pacer docket is represented here. But this isn't just about looking good. This is about making it in a way that people can understand. One of the most difficult aspects of big data is it's so difficult to comprehend. This is a form that allows you to navigate it well. In addition, we can learn stuff about the judges. Who are the judges involved? What's their information? What cases have they been involved in the past? What's the nature of the relationship? Are there magistrate judges involved? What's their deal? If you're assigned to a judge, you can learn about these people from the docket. Not only that, you can learn about the firms. Who are the firms involved in this case? Who are their lawyers? How are they litigating? Have they appeared before this judge before? What cases have they appeared in this court before? What is their record in such matters? There's all this information we can learn to make lawyers smarter. And attorneys, we can see, okay, this guy David, he seems like a good lawyer. What cases have they been involved in before? Has he ever appeared before this judge before? How do we know how to proceed? And even parties. If you want to know, say you're doing an M&A due diligence, what lawsuits are Google currently involved in now? How much litigation do they have? What's their exposure? There's all information available within Pacer that's just not able to be plucked out. This is a website that I hope to launch in some capacity in the next couple of years. But it's, sorry, not couple of years, next couple of months to change and revolutionize the way people use big data in law. So that's coming soon. But the future, and this is going much further down the road, the product I just demonstrated is totally feasible with today's technology. This stuff, not quite there yet. The future is what I call assisted decision making. This is giving lawyers data to make better informed decisions. And I want you to imagine a smartphone app. I call it Harlan, but you can call it whatever you want. It's called an intelligent litigation assistant. It's going to be something like Siri. So instead of just simply telling an app, Google me a contract for, Google me a template for a contract like LegalZoom. This is a little bit more sophisticated. You can actually ask a question to your app. You say, Harlan, I want to draft a contract with certain specifications. This tool will have been trained through many, many algorithms of how various contracts are drafted in different jurisdictions. And it knows, like Siri would on your iPhone, how to guide you to the right answer. You might say, I have a few follow-up questions. Where is this contract going to be executed? What are the remedies in case of a breach? Do the parties have adequate insurance? These are all the questions that an attorney would ask during a consultation, but there's no reason why a computer can't be trained to replicate that and give services to people who otherwise can't afford them. I think where this becomes even more important is when we talk about access to justice. When non-lawyers, people who don't have access to attorneys, can use this technology to better represent themselves. So let's use a similar example. Let's say you have a person living in low-income housing, and his landlord won't fix his heat. You know, what would a person do today? They'd have to go to a legal services office, probably wait an entire day, maybe take time off from work. This is not something that's feasible. But almost everyone has at least a smartphone or access to one. And they can say, okay, you have options. Here's a phone number. You can call the tenants' right department. You don't need to go wait in line in an office. There's a phone number you can call. Here, you can draft a demand letter, and we'll give you a template for one where we can just fill in the blanks with your name and your address, because this is a standard thing that a lot of people have to deal with. Perhaps there's a way you can file a pro se suit in small claims court, whatever the jurisdiction allows. This is something that's simple and straightforward, but a person might have no idea how to do if the situation is bad. Or maybe there's a listing of housing lawyers that offer pro bono services, and these can all be vetted quickly. This kind of technology will allow people to access justice in ways they simply can't today. But there's one problem here, and this is what I call the robot ESQ problem. And this is something which I think people should start thinking about. There are serious ethical, jurisprudential, and legal barriers to what I just described from happening. And we need to talk about these things because they will happen. The first issue is really what I call the ethical issues. Do we want computers having this kind of bond with people? Do we trust artificial intelligence systems to provide this counsel? The attorney-client relationship is hundreds of years old, if not thousands. And this is something which we have learned to trust and develop. By abrogating or delegating this role to computers and to smartphones, we are taking a lot of risks. What happens if there's a breach in the big data? What happens if there's a hack involved? What happens if a computer has a choice of zealously representing you or not? These are really serious PR issues which we really need to discuss. I'm actually writing an article called Robot ESQ, and I delve into these issues. The other interesting aspect is jurisprudential issues. What happens if we have AI developing law? The way our common law develops is over time lawyers make and change arguments to kind of advance stuff. Computers aren't very good at that. They're good at repeating what was done in the past. So there's a serious threat of the ossification of the law, or the calcification, if you will, where precedents that worked in the past will be repeated over and over and over again. And that might not be the best state. There's also an issue of bias. How do we know that people programming these algorithms have other motives? You know, with Google and their FTC suit, they were perhaps promoting certain companies and demoting others. How do we know that these algorithms that understand the law are doing it in a fair and unbiased way? We simply don't know. The real issue, and what we're going to get hit with first, is the legal and regulatory barriers. What do I mean by this? 3 letters, UPL. Unauthorized practice of law. We are seeing this already with LegalZoom, where we have sites that offer forms that can be filled out to do basic things like incorporation or to make a will. The way the law states now, the unauthorized practice of law by a non-lawyer is illegal. That's a very vague term. It's very ambiguous. No one actually knows what it means. A couple courts have actually litigated this issue, but really to no success. But what always happens is the challenger loses. The state's bar associations, they have an interest in promoting this homogeny. They have a monopoly. They have a cartel. They want to keep it that way. There have already been suits against LegalZoom in like 3 or 4 jurisdictions, and LegalZoom keeps losing. This will be the first front in how big data confronts the law. This will be it. We're already seeing this with Intrade, where the Commodities Futures Trading Commission is trying to shut down Intrade because they're saying that these commodity trades are illegal. I'm actually working on a side project with some litigation an amicus to say that there's actually First Amendment value in data. That data can have protected free speech value, and the government can't regulate it willy-nilly. And I think there will be some good First Amendment arguments made with the LegalZoom context, as well as in trade. So this is a rough overview. I think in the next maybe 5 or 10 years, data will transform the way we practice law. This is what I call assisted decision-making, where big data meets big law. Thank you very much for your time.
Next we'll have Cal Wilson from Georgetown School of Nursing.
this morning. I'm going to be talking about big data applications in scholarship and policy with a focus on health and healthcare. And I wanted to do that using a concrete example of work that we've done, that I've done with some colleagues at the RAND Corporation over the last several years that's focused on Washington, D.C. Some of you may be local and familiar with the city, and hopefully you'll learn a little bit about health and healthcare in the district while I'm really talking about some of these other big data issues. So about 5 years ago, the mayor's office came to my colleagues and I and asked us if we could help them to do a comprehensive health needs assessment for the community. And their narrow goal at the time was to help inform how they were going to spend about $200 million that they had available for investing in the healthcare system from the settlement of tobacco litigation. Along the way, the project morphed into something much bigger, and we ended up trying to inform how they spend about $2 billion a year on the healthcare safety net system. But when they came to us to ask us about this comprehensive health needs assessment, we quickly realized that if we would just gave them aggregate statistics about the health status of people in the district and their healthcare use, we would be really missing the full story. And I have a map up here of the percentage of families in the district who are living in poverty by census tract. So if you're not familiar with the district, it's about 600,000 people. It's divided into 8 wards, which are political districts, but people really identify with the ward in which they're in. And it's a really heterogeneous city. You have very advantaged parts of the city in the north and western parts, and very disadvantaged parts of the city in the south and the east. And what this meant for us as we were starting to do this health needs assessment was that we needed data that was granular, that allowed us to look at the health status and healthcare use of people, not writ large for the district, but what was it like in Ward 7? What was it like in certain census tracts? And so in order to be able to do that, we had to think carefully about what are the data sources out there that really allow us to track health and healthcare for a community. Now, we started this process about 5 years ago for the district, but it turns out that under the Affordable Care Act, one of the provisions is that every nonprofit hospital, in order to maintain its nonprofit status, has to do a community health needs assessment to look at its community, its very localized sort of market area, and understand what the needs are in order to figure out how they're going to spend the dollars that they are required to reinvest in the community. So this issue of granularity of data in order to inform health and healthcare needs is one that's going to be ongoing for hospitals, as every 3 years now, under the Affordable Care Act, they need to do this kind of community health needs assessment. So as we thought about the data, we thought about 3 different sources. One is survey data, and that's been the domain of health services researchers for a long time. And we have national treasures, like the Medical Expenditure Panel survey data. That's a federally funded, nationally representative sample of people who who give information about how much healthcare they use, as well as their socio-demographic characteristics. And it's a wonderful resource if you care about understanding health and healthcare at the national level. But the challenges with survey data are, when it's federally funded or it's nationally representative, oftentimes you don't have enough sample size in any particular state, or in our case, in any particular locality at a sub-state level, in order to be able to draw the kinds of conclusions that you want. The second issue is sometimes these survey data aren't geocoded, and that's a privacy concern. Now, for some data sets, there are provisions in place, for example, with the MEX data, if you want to merge characteristics of the location in which people live to the data, you can do that and analyze it in a restricted use data center. And that's the same for other data sets. So, for example, there's a national survey of children's health. And there you can actually create sub-state estimates of health status measures for children. And we ended up using this for DC. But these issues of sample size and the availability of geocoding are 2 of the big challenges of survey data when you want to get at more granular healthcare measures or health measures. So another source of data that we thought about was health insurance claims data. Now, this is big data in that if you have, say, 150,000 people in the district who are enrolled in Medicaid, every time they visit a doctor or fill a prescription or have an x-ray, that generates a claim, and all of those claims are compiled into this database, and we can track over time people's healthcare utilization. This is really rich data, Some of the challenges with claims data is accessibility. So for Medicaid claims or encounter data, you have to go state by state. There's no sort of national system of Medicaid data because Medicaid is a joint federal-state program. So this had a lot of rich potential for us, but access issues were key. And then third is other administrative data. So the healthcare system generates a lot of data. One of the other sources that we looked at for the district was hospital discharge data. So the DC Hospital Association has every hospital providing data to it on every inpatient hospitalization and every emergency department discharge that are conducted by district residents or other people who use district hospitals. So I'm going to show you some examples about the ways in which we used all three of these different kinds of data and how it helped inform us in our work in understanding health and healthcare issues in the district. And then at the end, I'll talk about some of the other data sources that we didn't use but that are emerging and have this potential to provide really important and valuable information. So first, this is some results from the National Survey of Children's Health. And so we were very lucky because this is a national survey, but they had enough sample in DC that we could not only look at healthcare outcomes for DC youth, but also look at children by ward within the district. And so this was a simple chart that we were able to put together that looked at a variety of different health outcomes. There were many more, but for example, the last row is asthma. So the percentage of children who report, or their parents who report that the child has asthma. And we can see that in Ward 7, it's about 18%. So the red cells indicate where the health outcome is worse than the city average, and the green indicate where health outcomes are better than the city average. And this gave us some information about the fact that asthma rates in Ward 7 are really much higher than they are in other parts of the city. And likewise in Ward 2, we have a greater share of children who report fair or poor self-rated health compared to other areas of the city. So there are many other health status measures that we looked at. One of the challenges with survey data is lag time. And also for the National Survey of Children's Health, this is only done every 4 years. So if you're a Department of Health or a public health department and you want to be tracking and monitoring, those are some of the challenges with these data. Nonetheless, it was an important part of the picture that we were able to put together. Secondly, we also used geocoded data from the Behavioral Risk Factor Surveillance System. This is, again, a federally coordinated survey, but each state does its own actual survey implementation. And what we did on the map on the right was to look at the prevalence of chronic conditions among district adults. And we were able to do that for different wards, the 8 wards in the city, and the darker indicate where the prevalence is higher, and the lighter indicates where the prevalence is lower. And then we cross-mapped that with some measures of the healthcare infrastructure in the city. So in particular, the red dots indicate where we have primary care physicians. And it was really the first time that for the district we could had this overlay of where the healthcare needs were and what the healthcare infrastructure looked like. Now that was important, especially for us as we were thinking about this $200 million and investing in the healthcare safety net. It wasn't only a question of whether or not we were going to invest in sort of hospitals or the ambulatory care side of the systems, but where in the city, where were there gaps in care, either for particular local areas or for particular subpopulations. On the right-hand side is a map that we did using cancer registry data. There are registries, cancer registries, I think, in all of the states. Every time a doctor diagnoses a patient, a new cancer case, that gets information that gets reported to the state cancer registry, and then also that data gets aggregated to the federal level. But with geocoded cancer registry data, we could look at the incidence of prostate cancer in the district, and then we mapped that to the location of urologists in the city. Now the supply side data was actually fairly limited. We didn't know which urologists took, for example, Medicaid or different kinds of insurance, but it gives us at least some broad sense of the demand and supply sides of healthcare in the district. I mentioned, in addition to survey data, health insurance claims data. So we worked with the 3, at the time, managed care organizations that serve the Medicaid patients in the district. And we're able to get information from them and pull it together. And one of the challenges, I think, with thinking about these other sources of administrative data, for example, is all of the work that has to go into understanding the data that's collected, the reason why it's collected, so that as researchers and analysts we can create meaningful measures, that we understand how these data are constructed before we go ahead and dive into them. And I think that is one of the key challenges for big data generally, is when it's not created for research purposes. So survey data comes with often a 50-page manual that describes how the measures were created, how missing values were imputed, what the codes are, how you have to use it to make national representative estimates. And all of that really is incumbent upon the researcher who's using these non-traditional sources in something like health insurance claims data. So this is one example. We did a lot of different things with these claims data, but we looked at youth Medicaid enrollees in the district, and we don't observe we don't observe health information about people who don't use care, but we do observe among those who use care, this is the number of cases of asthma, number of children with asthma across the city. And again, we saw this in the survey data, and another sort of useful idea here is the idea of triangulation, that we can learn some things from survey data and other things from administrative data to really get a full picture. So you can see the great discrepancy in the number of asthma cases, and this is helpful to the Department of Health as they're planning. Finally, I did mention hospital discharge data too. We were able to look at the universe of inpatient discharges among district residents, and these little pie charts show you for all the emergency department discharges from a particular zip code in the city, what hospitals did they go to? And the light blue there is Children's National Medical Center. Many of the emergency and inpatient hospitalizations were for youth, and almost all the children go to Children's National Medical Center. But you can see you have this diversity of hospitals people go to. Now, why is this important? One of the things that the district was investing in was health information technology, so that there is continuity of information across ambulatory care providers and the hospitals. So maybe I have a person who ended up in the emergency department, now they're at a clinic, and they want to be able to get that information. The person might not know which hospital they went to. If we are investing in that kind of availability or flow of information across EMRs, we might want to target those hospitals in that area, the linkages between the ambulatory care centers and the hospitals as depicted in those pie charts. So this was important for that reason. Another thing we can do with hospital discharge data is to look at potentially avoidable hospitalizations. This is a metric that's used to capture the availability and efficacy of primary care. And hospital discharge data, we have thousands and thousands of records, and so we can do this sort of disaggregated for different parts in the city. And this tracks over time, where are we seeing increases among district residents in preventable hospitalizations, which might say, hey, this is an area where we need to beef up the primary care infrastructure. So these 5 lines show us differences in preventable hospitalization rates over time across different areas in the city. And then I wanted to show this one quickly too, because we can not only take hospital discharge data with all the many records and look by age group and look across places within the city, but we can also look at specific diagnoses. These are inpatient hospitalizations for cellulitis, which is a skin infection. It includes something called MRSA. And we showed this chart. The top line there is Baltimore City. We showed this to the Commissioner of Health in Baltimore City, and he immediately came back to us and said, help us explore this further. They knew that they had a high rate, as you can see, compared to many other places in Maryland, but they didn't know about this trajectory. So this kind of surveillance can be incredibly helpful and focus them on the issue of cellulitis. And then finally, I'll just wrap up by saying that in addition to these data sources, which for us really helped us get at a granular level of understanding healthcare disparities across the city, there are some emerging sources. There are multiplayer, all-player claims data sources that are emerging. So we didn't have the ability or time or resources to actually get private health insurance data, but there has been an effort by an organization called Fair Health to take private health insurance data from across many large private insurers for the purposes of research. And then some states actually have all-player claims data, which could be incredibly rich, Vermont, Maine, and Maryland, so that you can understand not just Medicaid or Medicare in isolation, but also what's happening with the privately insured population. And then claims aggregators. So providers oftentimes, before they submit their claims to an insurance company, send it to a middle party that cleans the claims. And if you take the data from a large sample of providers, you can look at things like physician practice patterns. So what are physicians doing with their patient population? This is a really sort of very new area of research, and I know that, for example, HHS and the Assistant Secretary for Policy and Evaluation is very interested in these kinds of data, in particular because as the Affordable Care Act unfolds, we need very timely data. It's difficult to wait 2 years for survey data, and these different data sources give us access to really timely sort of on-the-ground data that allows us to observe healthcare reform unfolding. And then finally, other privately held data, such as pharmaceutical data. There are private organizations that aggregate all the pharmaceutical data from the Rite Aids and the Walmarts of the world, primarily in order to track physician prescribing patterns, but it has enormous potential for research and has been used for research in the past already. So I will end there and turn it over to the next panelist.
Now we have Kathy Zadler from Georgetown Law.
Thank you very much. I want to start by congratulating Kumar and Morgan and the rest of the library staff for putting together such a great program today. They always seem to be on the cutting edge of everything, topics and library service, so it's a privilege for us here at Georgetown Law to be able to work with them. And I think even though books seem to be becoming obsolete, we are relying, I think, more and more on the librarians and the library for our work, and so I am a huge benefactor of their hard work and dedication, so thank you. My talk today is going to blend together the subject matter of the first two panelists. I'm going to talk about litigation in healthcare and talk about some data that are helping us explore the medical malpractice liability system and its connections to medical malpractice insurance markets, which is one of the topics of my research here. So I'm going to talk about some new data sets, in particular the National Practitioner Data Bank, which is a federal level data set. And then I'm going to talk about how this data set has been used to study different sorts of research questions. And then I'm going to talk about some issues, some problems. So that's the breakthrough part, but it comes with some problems, some of which have been mentioned already. Getting information, sufficient information about how these data sets are put together to be able to use them appropriately. Not only that, but how the collection of these data changes the behavior of actors in the markets that we're interested in studying. It's really important to think about how data collection impacts behavior, and it can have very substantial implication for how we interpret the results of our research. And I'll also talk about some privacy issues related to this data set that almost brought down the whole house of cards, and how that got resurrected. So in the mid-'80s, Congress, the federal Congress, authorized the government to collect information related to sanctions applied by state licensing authorities against healthcare practitioners. And then a few years later, the statute was amended to require medical malpractice insurers to report every closed medical malpractice claim against a healthcare provider where a payment is made to close the claim. So today insurers have about 30 days from the date of payment to report. So the insurers that have to report are medical malpractice insurers who provide insurance against claims for healthcare providers, but also in addition to providing coverage, they provide defense. So they have defense teams, and they generally take on the defense of the claims, and so they have all sorts of information related to the claim, including how much it costs to defend against the claim. And so today, all reporting entities, including medical malpractice insurers, have to report information related to not only medical malpractice claims, but disciplinary actions. So state medical boards who discipline providers have to provide information. So disciplinary actions and closed claims have to be reported for physicians and dentists. And then there are all sorts of other providers, including chiropractors, emergency medical technicians, pharmacists, psychologists, social workers, acupuncturists, that also buy malpractice insurance. And when a claim is closed for one of these sorts of providers, the insurer must report the claim to the National Practitioner Data Bank. But other information related to sanctioning and so forth is optional for those providers. So there's a little bit of a difference related to what sorts of information have to be provided for different sorts of providers. So the purpose of this data bank is to facilitate a comprehensive review of the credentials of healthcare providers. And the data bank essentially just is an aggregator of information on sanctions and claims for use by insurers and hospitals, healthcare insurers, so not medical malpractice insurers, but healthcare insurers, hospitals, and other entities who employ, contract with, or license providers. So the legislation mandates queries in some instances. So when clinical privileges are granted by a hospital, for example, the hospital now must query this database to get records on the providers they're thinking about granting privileges to. And the hope here is that we can sort of rid the system of the bad apples that slip through the cracks. How do they slip through the cracks? So once a practitioner has several claims against him or sanctions against him in one state, it used to be very easy for the practitioner just to move to another state. And that information from the original state is very hard for any other state to get its hands on, and so that doctor could take up practice in another state. And so this is a way to aggregate information across states to help hospitals and other entities that contract with these providers to get the information they need to do the best hiring they can do. Healthcare practitioners also have access to their individual records. So that's nice. Healthcare practitioners can check to see whether or not there are errors in their record, and that can be useful for just cleaning up the data. So the U.S. Department of Health and Human Services is the organization that collects these data. They do the first step in analysis by issuing a report each year that summarizes the data and reports on how often insurers and others, hospitals and others query the data bank, so we can get a sense of how useful it is. It's very costly for insurers and sanctioners to provide this sort of information. So we want to make sure we're getting the bang for our buck, and this sort of analysis can help us figure that out. So the data that are collected are pretty wide-ranging. So there's information about the patient and the injury, including the patient's age, gender, the patient type, whether the patient was an inpatient or outpatient, the medical condition, the procedure that was performed, the allegation that was brought, so whether it was diagnosis-related or surgery-related or equipment-related, the injury severity, which ranges from emotional injury only all the way up to death, the year of injury, the payment as a result of judgment or settlement, and the amount paid by a state patient compensation fund. So a lot of rich information there for researchers who are interested in getting into some fine-grained analysis of malpractice injuries. There's also information about the practitioner that's collected. So the work state of the practitioner has to be reported, the home state, the state of licensure, the field of licensure, so that can be really important in terms of figuring out whether physicians might be overreaching, the age group of the physician, the school graduation year, and most importantly, for a topic I'll talk about later, the practitioner identifier. So of course hospitals and insurers have to be able to get the name of the practitioner. And this is something that has made it very difficult for researchers who are interested in medical malpractice to get information on the liability system side. So almost all of these suits that are brought settle outside of court. If something is brought to judgment in the court system, or even prior to that, if it's filed within the court system, or some procedure starts within the court system, all of that information is public record. But when the settlement occurs, the settlement is private. So it's very difficult for us to get information on settlement data. And since that's almost the entire universe of claims, it's very difficult to have a sense of what the general look of the universe is. And so the practitioner identifier makes this data set very controversial for practitioners. And I'll talk about that in a minute after I talk about the rest of the data. We also have information about costs related to the claim. So loss adjustment expenses are collected, things like attorney's fees and expert witness fees, and also the payment that was made to settle the claim in some range. So that's really important information. So researchers were given access, in addition to health insurers and hospitals, researchers were given access to the information, but only after the practitioner identification information was removed from the data set. So researchers cannot get that piece. And we typically don't care about that. For us, we're more interested in being able to look at trends and more global issues rather than looking at specific providers. So the data set's very useful for people who study the impacts of different legal rules on the medical malpractice liability system, because it's a national data bank, and we're able, using the data, to separate the claims out by state. We can look to see over time how different legal rules impact claiming rates, for example, or payment severity. So tort reform is a big area. A lot of people are very interested in the impacts of non-economic damages, caps, and joint and several liability reform, and on and on. And this data set has been useful along those lines. So researchers are using this data set for all sorts of research questions, including the impacts of the liability system on a whole host of issues that policymakers might care about. So I'll just give you some examples. In 1993, a study was published that explores whether small claims are likely to signal future large claims. So that's the purpose of the data set, is to identify and practitioners who are starting to get claims against them, and to try to determine whether they need to be just removed from the system. The finding was that the predictive value of the data on small claims is not very good. So the author recommends a cutoff for reporting paid claims at $30,000. So the recommendation is, the payment should be large in order to trigger a requirement for handing over the information. So these kinds of studies help to make the data sets a little bit more efficient in terms of how they're run. We only want to collect information if it's costly to collect it, if it's actually providing a benefit for us. And so those sorts of studies are really useful. In 2003, there was a study published using the data to test the impact of the reporting system on the resolution of malpractice claims. So I was talking a little bit before about being very careful and thinking carefully about how the data collection process impacts behavior of litigants. And this study found that physicians and their insurers have been less likely to settle claims since the introduction of this data bank, especially for small payments, for payments of less than $50,000. So the data bank, the creation of the data bank, has changed how settlement happens, and so that's a really interesting finding, something that might be an unintended consequence, and something that has very large impacts for interpreting general trends across time when we look at the findings. In 2010, the study was used. A study used the information from the data bank on the cost of processing and closing claims to help estimate the total cost of the medical liability system. And this was something that was very popular as we were going through the health care reform process and trying to figure out, where is the money going to come from? And a lot of people were arguing that the medical malpractice system is eating up resources that we could use for healthcare, and leading to all sorts of costs of unnecessary care due to defensive medicine. And so there was an attempt to estimate the total cost of the liability system, including defensive medicine. And the data bank was useful because it has information on the cost of processing the claims and payouts. Okay, now just in the last couple of minutes, I want to talk about issues that have arisen that present challenges and that I hope can be generalized to other sorts of government-imposed data collection efforts. The first is, again, just because insurers are required to report does not imply that they actually report. So the New York Times and some researchers have reported on the lack of completeness of this data set, and that's very important. So researchers have to be very careful about, again, just the data collection process. As Carol mentioned, it's very critical in terms of understanding whether you've got a random sample, right? So that's the key. You want to have a random sample of what's out there, and if the folks who are not reporting look very much like the people who are reporting, we don't have to worry so much. But if it's the large payment folks that are not reporting, or some subset that looks different from those who are reporting, then we have problems in terms of being able to generalize from the data set. Number two, beyond completeness, researchers have to be really cognizant of how the information requirements might impact decisions that impact what gets reported in the end. So I've talked about changes in settlement behavior. Some have reported evidence that hospitals will negotiate with claimants to drop doctors off of the lawsuit so that they won't need to report to the data bank. So that's incredibly important to consider and get information on, or at least throw it out there, so that we understand why the trends look the way they do. So if we see a decrease in claim rates, it might be because there is a decrease in claim rates, but it also might be because the market has figured out a way to avoid reporting claims that are happening out there against practitioners. Finally, one important issue on privacy related to this data set cropped up a couple years ago when the Health and Human Services Department restricted researcher access to the data after a reporter used the information in conjunction with public court records to identify a physician with a large number of entries in the data bank. And this journalist wrote an article about and named the physician. And then, of course, the physicians get riled up. So they pulled the data bank. They pulled it off the website and said researchers no longer have access to it. And one approach to this for researchers would just say, okay, we can't get it anymore, we'll use other sources of data. But we took a more active role. One of my previous co-authors put pressure on the government just by writing a letter to Sebelius and copying Senator Grassley, arguing that this decision should be reversed. Not only should researchers have access, but reporters should have access. And it's a public good, right? It's good for us to know whether there might be bad apples in the system. And Health and Human Services decided to reinstate access, but they made it illegal for reporters and others to combine the information from the data bank with other information for purposes of identifying doctors involved in settlements. So Charlie sent another letter, and we haven't gotten much traction on that front. But the idea is that the doctor's argument, which I think is has some merit, is that a settlement does not necessarily imply negligence. Right? So it's unclear what sorts of conclusions we can draw from the data along those lines. I think I will stop there. So just to wrap it up, the general takeaways I think are that researchers can have a big impact on the availability and composition of data collection efforts. And I think librarians can play a big role as well. So we talked a little bit about Dataverse. One very important aspect of Dataverse, I hope that will be tagged on to that project is not only to have the data there, but to have documentation, substantial documentation about how these data are collected, and one step further, limitations of the data set, so that any researcher who's using the data set can have a sense of what the limitations are, what others have found, to help them figure out how best to use the data. And I think we also have an obligation to warn readers about the inherent limitations of the data we're reporting results. It's really important for translation purposes. If policymakers are actually using these studies to make policy decisions, they have to be fully informed about the limitations of the data to make good policy decisions. Thank you.
And next we have Bill Leverty, who is the Digital Initiatives Manager for the National Digital Information Infrastructure and Preservation Program of the Library of Congress.
Good job in describing that very complicated name. Usually one or more parts of that are left out, so you've got all of them. That's great. So while we're setting up, I'd also like to congratulate Georgetown on 125 years of success. Over the years at the library, I've had the opportunity to work with a number of staff from the law library, Georgetown Law Library, and unfailingly found them to be helpful and really energetic and enthusiastic about the issues that we care about at the library, and in particular, digital preservation. Sorry. So, what I'm going to talk to you today about is stewarding big data. And I'm going to give you sort of a library and archives perspective on this. It's going to be at a relatively high level. And it's also going to focus on what's described as federally funded scientific research data. One of the terms here is stewarding, and that's a term that I'm actually very fond of. It's good because it really kind of sums up all the various activities that get involved in all the things that we need to do to be able to acquire, preserve, curate, and make available digital information. So rather than try to run through all those various activities, stewardship tends to be the one that, yes, tends to be a good sort of catch-all term. And as I think it's been clear from a number of previous speakers here, just the tremendous potential. In fact, it was very interesting to hear my panelists here talk about some of the realized benefits. Just having problems with little data here. Hopefully it will be revealed in due course. But I was very impressed with a number of the uses that are being put to data. And I think what we can see is that there's tremendous potential lies ahead of us in terms of what, in terms of being able to do some really, really interesting things in terms of scholarship and public policy. So, I think from my perspective, I could say that I firmly believe, and I don't think anyone here will disagree with me, is that we need to continue to move forward with our various kinds of stewardship activities, and we need to do a better job, basically, to be able to realize the full potential of big data. And there's actually quite a bit that's at risk here. The stakes are fairly high. We hear all the time about huge quantities of data that are being produced all the time. What you don't hear so much about is the risk of that data of getting disorganized, of getting lost, of becoming corrupt.
Is that?
That's it.
How far along should we go?
And basically what stewardship is about is mitigating those risks and being able to keep appropriate data appropriately available. And really what we're talking about are sort of two basic considerations for stewardship in general. One is that organizations such as the Library of Congress, but any kind of collecting organization that cares about data really needs to worry about what we call the full life cycle. Sometimes we only think about data as it's available for use, but to be able to realize the full benefits, to be able to get the best kind of data, to be able to keep it in the form that's most useful, it's really important to be able to start working on stewardship issues ideally as it's being created, and certainly as it's being used by the creators. And then, of course, the further parts of the life cycle, which are bringing it in, cleaning it up, and then making it available, also are critical. And as others have mentioned, I believe Leslie mentioned this, this is a job that really is far bigger than any one organization can handle on its own. In the old days, you used to see universities would brag, university libraries would brag that they have 3 million volumes in their library. And the idea was you have this sort of centralized collection of knowledge. We've moved way beyond that. We're definitely into this networked approach. And certainly when it comes to stewardship activities, we're looking at collaborative activities where data can be distributed among many different nodes or stewardship organizations. Yes. So I thought a good way to frame this discussion would be to summarize some inputs that were generated in response to a recent White House request for information. About a year ago, the White House came out with an RFI that asked for input into ways in which the federal government could ensure stewardship and encourage broad public access to federally funded scientific research data. Now, this is data that's generated from the result of funding that comes from National Science Foundation, National Institute of Health, pretty much any federal granting organization that gives money for research in which data is